since the court probably made a bit of an imprudent decision with regard to how long I kept the jurors here on Wednesday, and some of them had a difficult time getting home, and at least one juror had to stop and stay in a hotel, which is the first alternate juror, and I've advised counsel as to that situation. Last night I gave the jurors the option as to whether or not to start back today or to wait until Monday by having the jury clerk poll the jurors. All 15 jurors indicated that they wanted to continue today, and also that they could feel like they could be here by 11 o'clock today, and that's why we have resumed at this time. The decision was the jury's decision unanimously. One juror had to be picked up by Deputy Sheriff Bailiff to be brought in because of where he lived. It was unlikely that he could get here on his own. They'll take him home tonight after we adjourn. Anybody have any objection to those procedures that I conducted with regard to the jurors? Okay. There was some matter that y'all want to be heard about, somebody wanted to be heard about concerning late notice of discovery or something, Mr. Dellinger?
Yes, Your Honor. If I could approach this document. This is some discovery that the state received and provided to the defendant this morning. We would, as you can tell from the date stamp on the fax, this came from Grant Hayes Sr., and it's several letters from Amanda Hayes. I know the court ruled previously on some later item discovery that we were barred from using it, but this evidence we were unaware of, and it's highly probative, and that is reported love letters from Amanda Hayes to Grant Hayes from January of 2012, February of 2012, and then there's another letter from September 26th of 2011 where Mrs. Hayes talks about Grant Hayes, and we would offer that this directly goes to Ms. Hayes' credibility, and that it's extremely probative on that issue, and that it's admissible as competent evidence because it's a statement against interest at this point. And we asked to be allowed to use this evidence that came in this morning.
What is this? Came in from where?
So Grant Hayes Sr. called our office, I believe, this morning, early this morning, and indicated that he had some letters from Amanda Hayes to Grant Hayes. And so Ms. Holt and I called him back. He said that he had already faxed the letters over, and some minutes later we received these. But the first page is...
Grant Hayes Sr. Which Hayes is that?
That is Grant Hayes' father. Mrs. Hayes' co-defendant, Grant Hayes III.
Father. Sent these documents.
And Your Honor, these appear to be, what happened is that it appears that Amanda Hayes sent these to Patsy Hayes, Grant's mom, or to Grant's parents, for them to read over the phone to Grant Hayes. And I believe that's referenced in the first letter.
Were Grant Hayes Sr. and Patsy Hayes interviewed by law enforcement officers at an earlier time?
I believe at a very early time, Patsy Hayes was interviewed by law enforcement officers. I'll have to check on whether Grant Hayes Sr. was. But my recollection is that Patsy Hayes was interviewed.
And, Your Honor, if I may, the reason that they were prompted to send this is what Mr. Grant Hayes Sr. Reported to me was that in watching, that he said he had not been following the trial, that he turned it on a Wednesday, that he heard Amanda Hayes' testimony, that she was frightened of his son during this and had been threatened and had this, anyway, that she was in fear for her life during that process. And he said, I have these letters that I've just faxed to your office, which show that, after the arrest, after they're both in custody, that she is sending these letters to our home, asking us to tell Grant Hayes that she loves him, that she thinks about him every day, writes out a letter, hello, my baby, asks that be read to him. So that's what prompted. It's not, these are letters that came to them after the arrest and after Patsy Hayes had been interviewed, and that's how that came about, that he was prompted to call our office after seeing that last week.
Or earlier this week, I'm sorry.
Do you intend to offer this in rebuttal?
Yes, sir.
In what form?
We intend to offer it through Detective Falk as evidence that we've acquired as part of this investigation, and I would argue to the court that there's a hearsay issue with it. They're addressed from Amanda Hayes. It's got her inmate number on it, and we have the envelopes with them. Some of them are signed, Amanda, some of them are signed.
Do you have the originals?
No, they're in Kansas.
Do you object?
What we do, I would first note that we provided notice of a duress defense in this case some time ago. I know that the state did interview Ms. Hayes very early in the investigation. They were aware that there were phone calls from Grant to his parents. There's some notation on this fax cover sheet, which is obviously hearsay in every form, that references a telephone call from July the 13th. The state knew that Ms. Hayes had been in the home of Patsy and Grant Hayes with their son after the arrest. They've had over 2 years to talk with Grant and Patsy Hayes and to alert them to provide any information that they thought might be relevant to this investigation. I would suggest to the court that this information was not received pursuant to the investigation by Raleigh police officers, but was a fax from Grant's parents, and they're not here and subject to cross-examination. If they were, it would be our intent to talk with them and share with the jury the fact that they have been in custody. They've had the custody of Ms. Hayes' infant daughter since the time of her arrest on these charges, and Ms. Hayes has tried to maintain a congenial relationship with them in an effort to maintain some contact with her infant daughter, at least information that as to the care and well-being of her daughter, encouraging them to send her photographs and trying to get some assurance that her daughter was being well cared for. And certainly, I think, in light of the letter that Ms. Hayes received from Grant the third, while she was incarcerated, where he very clearly threatened her if she did not testify or share a story relating to the events of this case that would be consistent and favorable to a defense for him, that there's a lot to be explored, and that discovery that is faxed in by someone that's not even present in the courtroom doesn't appear to me to be admissible evidence under any theory, and certainly not basically on the eve of conclusion of the evidence and closing argument in this case.
Your Honor, I would just argue to you that that evidence that, I was looking for the date of the letter that Amanda Hayes claims was a threatening letter written to her in jail. But to be clear, the state had no way of knowing that these existed after they were sent out. But if it was sent from Amanda to Grant Hayes, we would have picked up on it. But the way that it was sent was to Patsy and Grant Sr., and then that was to be read to Grant Hayes. So I would argue that in the interest of justice, these are admissible. They're not hearsay because they're signed letters from Amanda. The information that's included on this cover page about the conversation that Grant Sr. had or that Patsy Hayes had, obviously we understand that that's inadmissible unless they come in here to testify.
Your Honor, I would just, in response to Mr. Jones's remarks, based on the mail that we received that was copied coming in out of the jail, it appears to me that if they missed this, it doesn't allow them to receive it by fax during the trial and offer it.
I understand. I mean, the manner in which the state seeks to offer rebuttal evidence, the evidence would not be admissible, and the objection sustained. The only manner in which the state could proceed with this evidence would be to call Patsy Hayes as a witness, have her testify that she received letters from Amanda Hayes, and what she did with regard to those letters, having received them, and identifying the originals. That would be a manner in which I think the rules of evidence would be satisfied. But other than, absent that, the manner in which the state seeks to proceed, the objection sustained.
We have one moment, Your Honor.
Object to late discovery and not having, I mean, if people are watching television and deciding that they now want to participate in the trial, I think.
You know, I certainly am very aware of late discovery with no notice. It always bothers me if there's late discovery with no notice at all, if one does not reasonably have that information available to them. But if this information is true, and Amanda Hayes mailed letters to Patsy Hayes, at least somebody sitting at your table had some notice of this information. And therefore, the late discovery without notice and the unfairness of it is mitigated significantly if this information is true. I note your objection and understand your position, but also believe that that would not preclude the evidence if it's offered in some lawful way that the rules permit. What's the state's intention? I mean, we can sit here and chat for another 30 minutes, or we can just proceed, but does the state intend to seek to admit this evidence in any manner other than the manner in which you just described?
Yes, the state intends to offer this evidence via, not through Detective Falk, but through Patsy Hayes.
All right. Well, we'll proceed on with completing the defendant's evidence. Whatever that is. Whatever that is. Defendant hasn't rested yet. Defendant can address anything the defendant chooses to in their defense, including newly discovered evidence as they see fit. When you finish your evidence, I'll turn to the state for a vote. All right? And you said you had one additional witness?
Yes, sir.
And then you now intend to call Patsy Hayes?
Yes, sir.
All right.
Your Honor, I would think we would like to have a moment to talk.
All right, we got jurors that came in, 35 minutes ago who,
Well, I mean, we didn't.
I know that, but I know that y'all have some evidence that you want to. I'm not telling anybody what to do, but I'm not precluding anything either. So we're still on your case, so you can do whatever you want to on your case. You now have some new information that you may choose to address on your case, or wait till the state brings it up. I don't know. All right, let's bring the jury in and finish this additional information that you had made reference to before we adjourn on Wednesday afternoon.
Your Honor, can I address the court about one issue, small
Okay.
issue concerning this exhibit? The transcript of Grant Hayes when he was in the Raleigh Police Department interview room, a good bit of that time he was in there alone talking to the aliens or whoever it was he was talking to. And we've identified the entire exhibit, but we only intend to play what appears on pages 13 through 30.
Okay.
And we have worked at the kinks with playing it on the screen. In those pages 13 to 30, there are a couple of times when the officers walked into the room
Okay.
about totally unrelated matters, like, do you want a cigarette, so forth. I have blackened out what the officers said and have prepared copies for the jury to read along with the Black Act
All right.
statements from the officers.
Fine.
Your Honor, we object to that, redacting the questions to the officers, I think totally obscures what's going on. I mean, will we be able to hear the officers' questions on video? Is that?
There will be brief periods on the video when the officers come in that you want a cigarette, can we take your handcuffs off?
Can you hear it? Can you
Yes,
play
Your
it so it can be heard?
Yes, Your Honor, as long
That's
as
fine.
nobody's talking, you can hear it on the speakers.